Hey, you guys, welcome. Kaosy Umeh here, aka Attorney Know It All. So, you guys, welcome back to this channel. And today we're going to talk about alimony, especially modifying alimony and when that can get really tricky. So, in this case, I'm giving you was one of my clients, and we just wrapped up her case last year in 2024. And her case is interesting because her case did not originate in Maryland. And when her case originated, it wasn't an attorney who drafted up a separation agreement. Instead, it was a mediator. So the mediator missed certain things that I would include and most attorneys would include in their separation agreements. And that's basically the whole reason we ended up in court. So I'll give you the little factual background now. My client and her husband got divorced in 2019. Upon their divorce in 2019, they agreed that her husband was going to pay alimony to her for the next 3 years. So that would have meant that he would pay alimony for the rest of 2019. And mind you, they got divorced around June. So he would have paid alimony from June 2019 to June 2020, June 2020 to June 2021, and then June 2021 to June 2022. So 3 years of alimony payments would have been over at the end of June 2022. So the what got interesting here is that my client got remarried in 2020. She got remarried, I believe, I want to say either October or September of 2020. However, her husband kept paying her alimony even after she got remarried. So he made his alimony payments all the way up to the end of June 2022. And he did not bring a case for a modification against her until 2024. Early 2024, we were in court. Early in 2024, he filed a case. We ended up in court at the end of 2024. So the question we had was, because her separation agreement or her divorce agreement was drafted by a mediator instead of an attorney, we were missing things such as when alimony would terminate in her case, and also, which state law would govern the agreement she made. So, as I stated earlier, she was not originally from Maryland. She moved to Maryland in 2020 after she got remarried. And of course, at that time, she was still receiving alimony payments from her ex. So the problem is, in Maryland, upon your remarriage, alimony automatically terminates. So unless your agreement states that alimony will not terminate, the de facto law is that it's going to terminate once you get remarried. So if we had gone by Maryland law, her husband would be completely correct. Alimony should have stopped upon her remarriage in 2020. Not June. She married October, September 2020. That's when alimony should have stopped. But the problem her husband has is that he was voluntarily making those payments. These payments weren't being made through a garnishment of his wages. This was him writing her a check to her every month for the amount that was owed in alimony. So my client's defense to this was that, well, he voluntarily made these payments, so there were gifts. And we also were going to use leches to defend my client's receiving of those payments. And what leches means is simply that if you have a case, the court wants you to be timely in your filing of it. So they don't want you to wait a year and a half later, like he did, basically, to tell the court, oh no, my rights are being violated. They want you to timely file it. And he waited almost a year and a half before he actually filed against my client. So those were my two clients' defenses. The second issue, though, is whose law controls this marital agreement? As I said, in Maryland, upon your marriage is automatically terminated. Alimony, upon your remarriage, alimony is automatically terminated. However, in this case, it did not originate in Maryland, and the laws in her state, her original state, weren't as strict as Maryland's laws on remarriage. In her state, in her original state, there were factors the court had to consider in order to determine whether or not alimony should have terminated upon remarriage. Her state actually had two conditions. You could either terminate upon remarriage, or if the other person began living with somebody else, and if that's met certain criteria. So, depending on whose states would govern, we could have argued my client could have argued no. If we're being governed by her state law, we could have argued, well, yeah, she got remarried, but her remarriage did not hit the certain factors of that state. Or the certain factors that state requires for alimony to terminate. Or we could go with Maryland standards, which clearly states that if it's not stated in your separation decree or your divorce decree, then alimony will terminate upon your remarriage. So those were the two big issues we were facing, because again, a mediator drafted this instead of a lawyer. So we had to go back and forth with the opposing party, and we actually ended up coming to a settlement. So in 2024, her husband filed for modification, and the modification was based on the alimony issue we talked about, but also because of, as I said, she relocated to Maryland in 2020 after she got remarried. So that also changed custody, the custody order that was originally provided. So he was filing for modification for the alimony, custody, and child support. So that's what we had to come to an agreement on when we went to court. So when we left courts, he ended up on her. So she didn't have to reimburse him. That we were very thankful of. Our agreement made it so that we were very thankful that that she didn't have to reimburse him, because she really didn't have the money to reimburse him. And he ended up he had been owing child support for almost a year, but he didn't have to pay the full amount that he owed over the year, because there was this issue about whether or not he should be reimbursed for alimony. So we ended up coming to the middle. We came to, okay, and I'm not going to say, I'm going to give you just example numbers. So he was owing roughly about $1,500 in alimony. And I'm giving these numbers because they're easier to calculate. So let's say he was owing the $1,500 in child support, and he had overpaid her about $2,000 in alimony. So we came to the middle there. We said, okay, that's a difference of $500. So let's go 50-50 on that $500 and say $250. So my client ended up reimbursing him $250 instead of the almost $2,000 he was asking about. And again, I'm just giving you general numbers that are easy for me to calculate. The number was just a little bit higher than that, but that's close enough. Anyway, my client ended up reimbursing him roughly about $250. She wasn't happy about it, but the problem was, if we went to court and we were going under Maryland statutes, yes, we had the defense that he was paying this voluntarily. We have the argument he was paying this voluntarily, and he waited so long that we could claim leches. But keep in mind, Maryland is an equitable distribution state. So our judges tend to care about equity. The question will also be, is it fair to have had him overpay this amount? Yes, he owes X, Y, and Z in child support. Or was it fair to him that he overpaid this amount? And the only reason he overpaid this amount is because he didn't know any better. Because he was choosing to follow a court order and he didn't know he could stop. And again, these parties were not represented by a lawyer when they got divorced. They had a mediator, and the mediator drafted up this agreement. So Maryland courts would have taken equity into consideration when making a final decision. That's why his attorney and we sat down, and we just had to come to an agreement that was fair to everybody and was reasonable to everybody. Because let's say, as I said, he owed about $1,500 in child support, and he overpaid about $2,000 in alimony. The courts could have gone, therefore, if we do the difference, she's going to owe him about $500 from the overpayments. But because of the deal we made, we're able to cut that in half, and that works. However, we also could have gone to court, and the court would have said, oh no, the laws from that state is binding over the laws of Maryland, because the order was drafted in that state. Our judge actually had the opposing party and I do memos describing why the judge. So my memo was basically telling the judge why they should go with her original state's law, and the opposing party's memo was about why they should go with Maryland law. But we never actually got this. The judge, we submitted it to the judge, but we never got a decision from the judge because, again, we ended up settling. But I say all this to say, if you're going through a divorce and it's at all just even a little bit complicated, get a lawyer. Not get a lawyer for the whole thing, but get a lawyer for the drafting of that agreement. Just that little, because I do that all the time. People come to me like, oh, we already agreed to X, Y, and Z. Great. Now let me put it on paper and check all the little boxes like who is going to govern this law and what happens when this happens. Because most people don't think about it, and mediators don't think about it, because at the end of the day, it's really not their job. There are a few mediators in Maryland I know who do think about it, but that's because they were former judges. The former judges are former magistrates. So either you hire an attorney to draft that agreement, or if you're using a mediator, try to get a mediator who used to practice law, because they will think about those small nitty gritties that they're so inconsequential. Well, I'm sorry, they're not inconsequential, but they're so little that they can be overlooked. But when you go to modify, when you go to amend, it's going to end up costing you thousands of dollars of money for something that would have taken your attorney or your mediator who has some legal experience maybe 5 minutes to just add a line into your separation agreement, and all this hassle could have been saved. Well, that's just me preaching. I hope some of you find this helpful. Again, if you want to go the route of a mediator, get an ex-judge or get an ex-attorney. There are many of them in Maryland. One of my favorites is an ex-magistrate from Montgomery County. He knows exactly what the law is looking for in a separation agreement. And if he had to draft one up, he would not leave you hanging, so that in 10 years when you're back in court for modification, the judge is going, well, who drafted this? And that was actually a question the judge asked us the minute she looked at it. She goes, counsel, who drafted this? Because she was ready to yell at one of us. And we're like, Your Honor, this was from the other state. We're both like, not I. Well, anyway, hope you guys find that helpful. Let me know below comments, and please don't forget to like and subscribe. And if you have any topics you'd like to have me address, please feel free to leave it below. I'd love to get back to you on that. And once more, please don't forget to like and subscribe. Until later, ciao.